Judge Tara Toohill subjected my daughter to a second unnecessary rape kit examination. CPS caseworker, intake worker, Paige Sears testified regarding allegations of the child showing some type of sexual behavior. These allegations came right before the parties went to trial for custody. They turned out to be false allegations. Attorney Tunis, which is my daughter's mother's attorney, she says, what was the nature? Obviously, I don't want to know who made the referral, but what was the nature of the referral? There were concerns for the child who was sexually acting out. And then I reached out to any concerning alleged perpetrators. In this case, there was none. However, there was some concerns brought up that behaviors were happening after visits to dad's house. Due to the CAC interview and medical exam, there was not sufficient evidence that any sexual abuse had occurred. Sufficient evidence that anything had occurred. She said it a second time. So I asked her a third time. So you said there is no sufficient evidence that any sexual abuse had occurred? She said yes. On page 17. So you didn't find any evidence of any type of sexual abuse. That Paige Sears answered. She said that's correct. A medical exam was done as well as an interview was attempted. At this time, there's no sufficient evidence that sexual abuse has occurred. Day 2 of trial was months later. Judge Tara Toohill removed all of my custody, and her reason for removing custody was on line 3, you say the child, Sadia Thurston, shall immediately undergo a medical examination seeking a determination on whether or not the child is being or has been sexually abused. The medical examination shall include a rape analyst kit and an adolescent's gynecological exam, preferably by an expert in the field of child molestation. The child shall undergo an immediate health screening by a pediatrician. The court recommends that the child be brought to the Geisinger Danville Children's Hospital room immediately within 4 hours of this order. The emergency room is located in 100 North Academy Avenue, Danville, PA. This temporary order is based upon allegations by both the mother and father that the child is being sexually abused by someone in the other party's home. This is almost a year after false allegations was made that child was showing some behaviors after coming from my house. This is a year later. That case was closed in May of 2023. She put this order out March 14th of 2024. The mother first reported her concerns of abuse to father when the child acted/communicated as if she were attempting to perform oral sex towards mother. All of this can be seen on episodes 15 to 24. This is all from October 2020. She's relitigating this the entire case from 2020 and 2021, except we're not going through everything. She's saying she's taking judicial notice, but then she's cherry picking throughout the case to use certain things that's going to fit her false narrative. And this is the judge that is doing this. Now it says, father testified on March 12th that he witnessed a child exhibiting sexual behaviors prior, but had not told mother. This is incorrect and it's not true. And all you have to do is, again, if you watch 15 to 24, I've never witnessed a child exhibiting sexual behaviors prior, but not had told mother. That's the exact opposite of what was going on. I was constantly reaching out to mom. 9 times I reached out to her trying to figure out what was going on with my daughter. I did not know it was sexual abuse. I thought it might have been physical or some type of verbal abuse, like she was being scolded or something. Father testified on March 12th that he witnessed a child exhibiting sexual behaviors prior, but not had told mother. That is fabricated. That is not true, and it's nowhere in the record. The closest thing to that she could be talking about was when I smelt this smell on my daughter, and I did not know why she was smelling like that. Episodes 15 to 24, it describes everything, and this was all part of litigation in 2020 and 2021. This is none of this stuff is like new information. So number 9, she says the court is extremely troubled by the information that was received on trial on March 12th. So you'll see later on in the trial, the May 3rd trial court opinion, the reasons why she's saying the court is extremely troubled. One of the reasons is because I remembered the exact date of my daughter's menstrual cycle. She sent my daughter for this unnecessary rape kit examination, and then after I called her out on it in the emergency petition for special relief, The courts granted me 1 hour per day to talk to my daughter. So this is only up until the May 3rd order. After the May 3rd order, she cuts all communication. So I'm not even allowed to talk to my daughter on the phone anymore. During the emergency petition, restrictions concerning sexual abuse against minor child and have been litigated before two competent judges of this jurisdiction. The defendant and family has endangered the child multiple times based off of Exhibit B and C, and false reports were made to law enforcement and courts in all cases mentioned above. These lies by defendant and family concerning subject child safety were caught on record. Different cases and Supreme Court rulings, the Americans with Disability Act, the Equal Protection Clause. And at the end, I said, Judge Tara Tuhill was aware of all sexual allegations a year ago and took no actions to investigate these allegations further until day 2 of custody trial. Court records, texts, and previous orders show these allegations were made with malicious intent and retaliation due to plaintiff trying to abide by previous court orders. Exhibit B and C concerning sexual abuse by defendant's family. I filed that emergency petition. Now it's being heard on April 15th by the same judge. This is Attorney Tunis questioning her client. Did you receive the March 14th order of 2024? She said yes. I took her to Geisinger and Danville to get evaluated, the rape kit evaluation by the doctors. What was indicated to you? So she said the doctor said that normally a rape kit is done within the first 72. She wanted to inform me that it was done within the first 72 hours, and she asked me if anything specifically happened within those times. And then they did their evaluation. They told me that her hymen was in check and that they couldn't confirm or deny that anything had happened to her. So Ms. Tunis says, I have no further questions at this time with respect to that issue, Your Honor. The court, Mr. Thurston, do you have any questions? And then she looks back at Sonny and she says, were you trying to say something? Sonny starts speaking again before I question her. And she says, the first time she got evaluated, the video that you watch her speak, she was physically examined then too. And then the court says, okay. And then she says, and that was when they said that everything looked normal and they could not determine it either. So the same day all of that was done. So that should be on her record. The court. So that has never been told to the court, and I have not received a paper of that. That was never a written letter by the CAC regarding there have been a physical exam. Were you present in the room? So mom is shaking her head yes. She says yes. So you're saying it was a gynecological exam? Mom says yes. So right after she did the whole speech part, we went right next door. They took us into another room, and I spoke with the doctor for a while, and they brought us Sadia, and they did a full examination. So now what Judge Tara Tuhill is trying to do, she knows she made a mistake, and rather than just admitting to it, she's trying to justify it. She tried to blame it on mom. She says, so that has never been told to the court. And that's a complete lie. That has been told to the court, not only by mom, but by the person who did the investigation. Go back to day 1 of trial, which was October 3rd. Ms. Sears, the CPS intake worker, page 13. Due to the CAC interview and medical exam, there was not sufficient evidence that any sexual abuse had occurred. And I questioned her one last time. I said, so you didn't find any evidence of any type of sexual abuse? She said, that's correct. A medical exam was done as an interview was attempted. At this time, there's no sufficient evidence that sexual abuse has occurred. The judge says, so that has never been told to the court, which we just seen on day 1 of trial. That has been told to the court multiple times. So that has never been told to the court, and I have not received a paper copy of that. There was never a written letter by the CAC regarding there having been a physical exam. Were you present in the room? And then she says, so mom is shaking her head, yes. Miss Watson, yes. The court. So you're saying it was a gynecological exam? Mom says, yeah. So right after she did the whole speech part, we went right next door. She took us into another room, and then I spoke with the doctor for a while, and they brought Sadia in, and they did a full examination. Did they also report to you anything from that or no? No, they said they can't confirm that anything is going on. The court. So was there a rape kit performed? I don't know if that's what they call it when we went there, but it came up on the screen like a microscope thing, and they did the full exam. It was no swab or anything. So the court says, what you're talking about right now, that's at which hospital? She replies, that was the one where we went to where she got questioned. The court in Philadelphia? Yes, the court. So you're unsure if they did the swabbing at Geisinger? They didn't do swabbing. The court. So they did not do swabs. Miss Tunis, Your Honor, if I'm not mistaken, I believe that Miss Sears had testified to the extent of the evaluation when she testified during the October trial with the children and youth. I could be mistaken. I obviously don't have the transcript, but it was my recollection that she had indicated the steps that had taken place at that time. So at this point, Sani's attorney jumped in to save the judge from digging an even deeper hole for herself. The next thing she does, she says, Dad, do you have any questions for Mom? And I said, yes, I do. And then she says, okay, go slowly, talk one at a time to the court reporter so the court reporter can get both of you the question and then the testimony. You may proceed. So as I'm proceeding, the judge's face is like bright red, and she's looking at me with the most meanest look on her face. I start off by saying, so when you take her to Geisinger, the most recent time for her second rape kit, when did you take her for that? What was the date and time? Okay, so she says the previous first rape kit was in March of 2023. Okay, now page 12. So the child was subjected to a rape kit in March of 2023, correct? So as I'm questioning her, here's the judge again. She's trying very hard to protect herself now in the transcripts. After I say, so the child was subjected to a rape kit in March of 2023, correct? She intervenes. She says, just to clarify, a rape kit is something that I had sent the child for that mother testified that they did not do that. She's not aware if they did it. So just for terms, I think what mother did was, you're saying at the CAC, which is the Child Advocacy Center in Philadelphia, that there was a forensic gynecological exam, which is separate than a rape kit, a 72-hour rape kit. I know you're using that term, but just for the record, they're not synonymous terms. But I'll let you continue. They're not objecting to it, but I need to say for the record.